Hello, everyone, and welcome back to another episode of Unplugged. Today, we are joined by Vikas Mahendra, who is a specialist arbitration practitioner and is a member of the Chartered Institute of Arbitrators. Currently, he is a partner at Keystone Partners, Advocates and Solicitors, specializing in public international law, international arbitration, and dispute resolution. Before joining before joining Keystone Partners, he worked for over 6 years in the Arbitration and Litigation Department in Herbert Smith Freehills' London, Paris, and Singapore office. So Vikas brings with him the experience of working in jurisdictions across the world. He is also a dual qualified lawyer. He is admitted as an advocate in India and as a solicitor on the rules of England in England and Wales. He is graduated from National Law School of India, University Bangalore with top honors in 2008, and he continued his academic brilliance when he was studying for his masters in the European Masters in Law and Economic program in 2009, where he was ranked first across the program and was awarded the best thesis. Vikas has also been at the forefront of leading the AI technology revolution in dispute resolution, not only in India but across the world. And we will talk about it during the course of our recording today. But before we do that, Vikas, just wanted to, so our readers can get a context to this conversation, our listeners can get a context to this conversation, and the viewers as well. Can you talk about your days in Bangalore and how you moved to London, I believe, and joined Herbert Smith Freehills?
Right now, thank you for that very kind introduction, Paras, and lovely to speak to you, Akash, as well. The journey was very interesting, actually. I never intended to do law. I was a very typical Bangalore boy with, engineering and medicine fed into my DNA. But somehow law happened. It was a very happy coincidence, but I'm glad it did because, frankly, if I had to turn the clock back and do anything different, certainly another stream wouldn't be what I would do. I was very happy with what I did. And doing law from a place like NLS Bangalore at the time was eye opening from a number of different perspectives, starting from being exposed to people from a variety of backgrounds, and that is both from within Bangalore, within Karnataka, across India, and over the course of the law school journey, with people from across the globe. And that foray into London was also a result of a little bit of that exposure. So I did, as a lot of arbitration practitioners these days, start my arbitration journey with the Wismut. So I went to Vienna, was fascinated by how arbitration was conducted internationally, how much interest there is, not just within India, but across the world. And the fact that we were able to do decently well in a worldwide competition gave you some confidence that, maybe you're not that terrible. And that meant I started looking for opportunities to do arbitration more full time. And at the time, there were very few outfits in India which did arbitration exclusively. And I think a little bit of that continues to be the case today, but at least now there are some green shoots of arbitration specialists. But back in the day, it was not really the case. And the places you could do it were mostly based out of India. And I was lucky enough that some of those places came to our campus for recruitment, including Herbert Smith Freehills. Lucky enough to get through their interview rounds. And even once I moved to London, it was fortunate that I ended up doing a lot of work in their arbitration seat. So I started with their international arbitration team, then their construction arbitration team in London and Paris. So that's sort of how, from an academic interest, it became a professional interest. And in that time, I ended up doing a lot more construction arbitration than any other kind of arbitration, which also was exciting in its own way because each dispute required me to learn another field of technology and civil engineering. And I liked that. And that's sort of how that journey into arbitration started, with London being the first stop.
Okay. So, Vikas, continuation of what Paras was asking, I think the next point will come across that you have worked across offices, right? When you were at HSF, you were in London, you were in Paris, you were in Singapore. Now, coming from HSF and shifting to Keystone and back to India, making it your base for arbitration, how was the adjustment period? How was the change in role? How was the change in terms of practice and in terms of the peer you are arbitrating against? How was the change when you came to India after being working outside for a long time?
Uh, it was very rocky. It was definitely not smooth. Firstly, because while I'd done a few internships in India, I had never really worked here. Right? I started off my professional journey in London. And when I moved back, the idea was that I'll take a little bit of what I've learned over those many years of working there back with me and maybe do a little bit of that in India. I was working for a number of Indian clients even while I was in London and Singapore. So I thought maybe some of those connections will stand me in good stead. But it was a rude shock that the people who will blindly trust you when you're with a foreign law firm will find it hard to repose the same sort of trust once you're back with your own outfit. So it was definitely a challenging time when I came back, and it was not as easy to do the kind of work that I was doing. I used that time to do a little bit more litigation at the time because, frankly, I didn't have enough arbitration work when I came back. And that helped in a way because in India, as you know, litigation is very intrinsically intertwined with arbitration. And if I had continued to do just arbitration, then maybe I would have done some disservice to my clients because I would have probably not known half of what the strategic considerations are. So, perforce, I ended up doing a little bit of that. But on the arbitration side of things, it started off with a lot of frustration. There were so many things that were here which I didn't agree with, but were so part and parcel of the process that I had to learn and get on with things. And top of that were two. One is marking of documents. I distinctly remember when I came back, having done arbitration for whatever 8 years, 10 years, and I went into an arbitration hearing here in India with three eminent arbitrators. And for 3 days, we sat and wrote exhibit numbers on pieces of paper. I'd never done that. In fact, the whole process of marking and admission denial of documents was alien to me. And I felt there were these processes that had flown in from the CPC, which were wholly unnecessary and made the whole process extremely inefficient. The other such was lack of transcription. So while doing arbitration internationally, where whether it was arguing, whether you were cross-examining witnesses, there was no real break, right? You went with the flow of your questioning and responses, so you were able to get a lot more done in a given day. Whereas here, with stenographers being at the helm of affairs and your ability to proceed being dictated by the speed of the stenographer, it was extremely frustrating, and it also meant that the witness got away a lot of times, either because they were able to correct their answers or because they had a lot more time to think. So some of these processes were a little tricky. It took me some while to adjust, and I will confess that I don't think even today I have fully come to terms with it. While I understand it, I don't think I agree. But yeah, that was the transition, and it wasn't the
So,
smoothest.
So it's interesting to talk about, transcription in arbitration, and not only in arbitration. I mean, I think today, in the modern practice of law, especially after COVID, it has changed a lot.
Yeah.
And now live transcription has become a major part of advocacy, not only in tribunals but also in the Supreme Court. And for those of our viewers and listeners who might not know, Vikas here has been spearheading that revolution in the sense. In the Supreme Court now we have live transcription of constitution bench matters, and it's the software is TERES, and it is something that has been created by Vikas. In the last 2 years, I've seen TERES not only in Supreme Court but also in most of the arbitration conferences I have attended in Delhi across India. And I believe you are now also in Paris, in Geneva, and Singapore, and every major arbitration center, right? So, Vikas, how did that happen? As a pure play arbitration lawyer, how did you decide, or what made you shift your focus to AI and tech in dispute
also,
resolution?
Vikas, before you answer that, I would also like to say that we have also been recipient of TERES services in view of our arbitration. So,
Yeah.
Yeah.
Yeah, no, thank you. And firstly, thank you to what Akash was saying. And it is users like you who actually make it worthwhile to even try and innovate in whatever little fashion we do. The interest in tech was actually long-standing. I mean, like I started off, right? I was that Bangalore boy who was trained to be an engineer. So it was not that technology was very far away from my DNA. And even through law school, I was part of the law tech committee. So we were looking at that interplay of law and technology. Obviously, I didn't do anything about it until I came back. But it is that frustration I was talking to you about which really led me down that path of trying to do something which makes a difference. Even internationally, while they do have things like transcription, they're ridiculously expensive. I mean, transcribers charge more than partners at top tier law firms. And I said, that's really not what it should be, right? It's an aid, it's an administrative tool. So we said, can we try and do something differently? And it is around that time that my brother and brother-in-law, both of whom are engineers, started talking to me about how there's fintech, there's medical tech. Why is it that we don't hear enough about legal tech? And this was what, 2017, 18. And I said, it's because lawyers are inherently averse to technology adoption and they will fight tooth and nail against anything that will change status quo. So it's been difficult, but there's no reason why the younger crop of lawyers who are digital native, who are used to doing things more efficiently, won't embrace it. So maybe it's worthwhile at least trying out with some solutions. And that's sort of when around 2017, 18 is when we started. And like you said, Paras, COVID was a paradigm shift. And even lawyers who were traditionally averse to technology adoption now said, unless I do this, I am going to get extinct. I will not have my livelihood. So I need to adopt. And that mindset shift really helped us. While, of course, that was primarily for COVID and video hearings, etc., it actually signaled something slightly deeper. It signaled an intention to do things differently, which they didn't want to even experiment with earlier, which is why you will see today things like liquid text, right? It's not my product. But it is so popular because people now felt like, it's possible to do things digitally. And if I can do things digitally, I will use tools that will help me do it a little better. And that also percolated into being open to looking at solutions like transcription that TERES offers using AI. There is still some resistance from some quarters because this whole fear around what is AI, what's going to happen to my data, what is it that this will mean for the remainder of everything that I'm doing, are concerns that continue to plague people. There are answers, but I think it takes time for you to really understand where the boundaries are, and some people are still a little wary of it, but certain others have come around, and law firms such as yours have used transcription and you've seen the benefits of it. There are others who don't want to do it for other reasons. Like, I don't want everything I said to be recorded because I don't want to be held accountable. Because there are arbitrators who will discuss cricket and football and God knows what during arbitration hearings. They don't want to record it. So there is also that mindset shift. And there's a number of these battles that we are fighting to try and make it mainstream.
Insofar as the firm is concerned, I think the credit goes entirely to Akash. He has been pushing all of us to, use AI more and more. Not only in transcript, but I think in most facets of our practice now we are using some sort of AI or the other. And Akash has been trying to find ways to automate everything we can. If there's a way to automate something, Akash will find it. But now when we talk about AI, and you brought up this really important point about data and confidentiality, and a couple of weeks ago at the AAA conference in Delhi, there was a panel on AI, and I think one of the major discussions was around confidentiality. Obviously, the data you're feeding into AI, we are bound by client confidentiality. So what happens to that? And though we have had, platforms like Relativity for a while now, how do you look at AI not only in terms of transcribing, but actually playing a much more important role in day-to-day legal practice? For example, uh, a large language model where you can actually upload the data, the documents, and something which bring turns out perhaps 90% or 95% to go, a draft of a petition or a statement of claim or so on and so forth. How do you look at that conflict, and how
Yeah.
can
No.
we sort of resolve it?
Yeah, no, Paras, very important question. And while I did say that that's the reason why people have been hesitant, it is actually a reason that one must definitely be careful about, because you are rightly said, there are issues of confidentiality which trump everything else. It trumps efficiency, it trumps any ability to do more work. And I think the answer lies in curating. If you had to use, say, a chat GPT to do the kind of tasks that you just discussed, you would definitely be looking at breaching confidentiality, and then the repercussions are significant, especially in the field that we are in international arbitration, where confidentiality, client attorney privilege is paramount. You can't even dream of doing something like that. So it's not using solutions like that. It is really about trying to find solutions where you can protect data, you can protect the confidentiality without necessarily giving up on technology altogether. So let me give you an example. When we're looking at AI, right, let's say the transcription to start with, and I'll talk about large language models also in just a bit. Transcription engines now, the way we design it, are entirely hosted on our servers. We don't send data to any third party. We are bound by confidentiality obligations, non-disclosure obligations, which are far more stringent than you would probably even adopt in physical paper world. And we have data purging and retention policies, which ensures that absolutely none of the arbitration data is used to train models, and it is not retained on our systems post a hearing. So while you are using AI to process, you are not using data to train. And that's why to understand AI, you need to think of it as having two parts. One is the training model, and the other one is the inferencing engine. So what you do with a training module is you feed it data, it learns from your data, right? So it becomes better. But what you do with that training is that you apply it, and that is the inferencing engine. So you use that information on a certain set of documents, data. Using the inferencing engine is not the same as using the training module. So if you're using only the inferencing engine, you're not training the data. And that's how you build these solutions. So you'll say, I'll train on publicly available data sources, but once it's trained, I'm going to literally unhook it from everything else in the world, host it in a private, secure environment, and use it only as an inferencing engine. Or even if I'm training it, I'm using it as a training module only for that particular purpose. And that's how you can curate AI. We now have modules which are so small and yet so powerful that we can literally put it on a powerful machine, cut the internet off, and you can still use it. And that's the kind of example I give to say that's how secure your data is. You can go into a bunker during a nuclear holocaust and you would still be able to work on all of these modules, because that's how we've built our systems. So it is taking that care to ensure that this aspect is taken care of. It is possible, it is not automatic. On large language models, we have again been using large language models to do exactly the kind of things you are, but maybe even going beyond, right? So, for instance, we're currently working with a very experienced arbitrator on a project where we're looking at whether we can automate drafting of arbitral awards, not the decision, but everything else around that, through AI and large language models as, like you said, a 90%, 95% accurate draft. And the only reason this arbitrator, an internationally renowned arbitrator, is willing to engage in our process is because we spent several days explaining to the person, taking them through our algorithms, taking them through our models, and explaining how none of that data is going to leak this confidentiality ring that we have established. And it is only after being satisfied that that engagement is going ahead, right? So that I'm giving them as an example to say large language models also are capable of being used with that kind of a ring fencing that we talk about in another contexts. The Supreme Court's doing it with transcription, like you mentioned, also after being satisfied of all of these parameters. Similar again is the Singapore Supreme Court, which is currently working with us on a potential engagement, Dubai International Financial Courts on a potential engagement. And when institutions of this caliber are looking at it, right, that's where layman users like you and I can gain some comfort to say if a credible institution is doing it, clearly they must have ticked the basic boxes. So maybe I don't need to become a software engineer and understand all of these.
True, true. So, Vikas, now we've spoken about AI, but just want to circle back to something you said a while back. When we were talking about your experience in UK and, the major reason you moved, and then you said that, there's been some green shoots across the country, but as a legal, jurisdiction, India is still perhaps not there where it ought to be. Uh, so, as practitioners, all of us are now arbitration practitioners, and I think we are driven by the same ambition, which is to put India on the world map when it comes to arbitration, right? Uh, what do you think is the correct way to go forward? I mean, we have had a lot of conferences. There are at least a dozen conferences every year. There are arbitration weeks. We have foreign arbitration institutions coming in, setting up committees, India focused committees, and these things are happening. But on the ground, what do you think should be happening perhaps today or in 5 years from now or 10 years from now, but to
Yeah.
be there, to perhaps be the second Singapore for Asia, for example, or the second Dubai for Asia?
Yeah.
What should be done?
So I'll answer that second part of that question a little later because I have a slightly different view on whether that's even desirable. But let me answer the first part. I think a lot has been done to protect to give immunity to arbitrators. So if you look at the entire process of arbitrators, like you're shielding the arbitrators a lot by preventing them from being accountable for anything. I think we need to really move from that position to a position of accountability. Arbitrators at the end of the day are an independent contractor, right? If you look at it from a purely contractual point of view, they're not an employer-employee relationship. It's not a fiduciary relationship. What is it? It is a contractual relationship, which essentially means that there is some rights and obligations both parties have with each other. But why is it that arbitrators are left with literally no accountability? And I think that really is the starting point of the problem. It's not technology, it's not anything else. I think it's more fundamental. It is about tightening the screws on accountability. That means keeping them accountable for time, keeping them accountable for quality. And if you keep them accountable for these very basic things like due process, time, affordability, they will inherently start using tools which will aid them in that journey to become more efficient, more affordable, because they can't do the things that they're doing, with a 10-year horizon for a completion of an arbitration proceedings, if they had to do it within 12 months with consequences for not doing it within 12 months. So really it is about tightening the screws there. Now, how do you do that? I personally feel that institutional arbitration is the only way to do it. Courts appointing arbitrators is a big problem because they simply don't have the ability to monitor performance post appointment. Is the arbitrator doing things well? What is the quality of arbitral awards? How many arbitrations do they have? Have they been able to give parties enough opportunity to present their case? Do they have too much of a work? They simply don't have that data point. Institutions have them, and they pride themselves. Good institutions pride themselves in their panel, in their appointment process, in their ability to oversee the arbitral process. So I think institutional arbitration is a massive step forward to get us in that in that path of being a good arbitration friendly jurisdiction with quality awards. And I think as part and parcel of that will mean getting younger arbitrators to become decision makers. It comes with its own challenges. Younger arbitrators inherently mean that they are inexperienced being arbitrators. They may have been fantastic counsel, but as arbitrators, they will be inexperienced. So, how do we get these younger arbitrators trained to be qualified arbitrators is a challenge that we will have to meet. And that's also where I think institutions can come in. Training programs, ensuring that you have tribunal secretary courses, award writing courses, and all of these as a prerequisite to empaneling them and getting them appointed. Those are the kind of things, again, an institution can do, courts can't do. So younger arbitrators, institutional-led arbitrators will, I think, solve most of the problem. And if that can, on the other end of the spectrum, be supplemented with courts also being a little bit more encouraging of institutions having a little bit more free hand, whether it is by saying that, listen, you don't have unlimited time to file submissions. I am not going to give you endless opportunity to reopen a case, file recall applications. And if courts stop seeing that as due process violations and genuinely recognizing that, there are these procedural controls that institutions and arbitrators have, that will aid the process greatly. There is currently this due process paranoia, as people call it, right, which plagues arbitrators. And if we can do enough to rid them of it and get them to feel empowered, I think that's a good step forward. I also feel that in that journey of accountability, a concept which a lot of people find just obvious in arbitration, which is finality, I think we need to relook at it. I will get whipped for saying it,
You know,
but
that is actually what I was thinking about, because
I
at
think
some point you need to
that is
have finality to the appeals as well. You cannot go
yeah.
up to curative 10 years
no,
later and then
that is has been the
have the
burning
entire
point of
thing
all
set
the
aside.
arbitration discussions we have so far. But I think Vikas, I just you
Yeah.
pointed out an interesting point because I remember I met you in the last ICC conference in Bangalore. And there was a mention of ICC rules were talking about something about like a penalty or some kind of remedy for the claimant or the clients or the parties approaching the arbitrator in case the arbitrator can be held accountable for in terms of delay among other things. So what are your thoughts on that? Have you come across something else along the lines, or would something like that be applicable in India within like near future? Or
Yeah, so actually, I come in from a point of you're absolutely right. This whole DMRCL case, where in a curative petition they started overturning things, is ridiculous. But I think if you look at it a little deeply, right, how do you ensure accountability while also keeping finality in mind? I think that's the balance that we've got wrong. And the courts are struggling because they feel really helpless, right? They see poor, ridiculous awards and they say, okay, how do I uphold this? And that is a genuine problem that courts feel, and we can't overlook that. And that's what I was saying, maybe we need to start relooking at the finality of arbitration a little bit and maybe get some guidance from what specialist arbitration institutions which have survived 100, 200 years have been doing. So if you think of, let's say, the Grain and Food Trade Association arbitration, the GAFTA, they have an appeal mechanism within the arbitration institution itself. If you look at Centro Trade in India, which talks
Even
about tiered arbitration.
Exit, for example, Exit has
Yep.
very restrictive grounds for annulment of an award. They're very restrictive, and
Yeah.
they've worked for almost like 70, not 70, but they've worked for almost quarter of 50 years.
Yeah.
And I
No, in
think
fact, I'm
something like
saying.
that should be imported.
Yeah, no, but I'm saying, Paras, I'm actually saying something exactly the opposite. So in ICSID, the grounds of challenge are very limited. Whereas
Very
in
limited. Yeah.
GAFTA, the grounds of challenge are actually unlimited. If you think about it, you can actually challenge an award on merits within the GAFTA framework.
Within the
But
system.
exactly, right? And
Within the
that's really
system.
the
Yeah.
exactly, and
Yeah.
that's the
Yeah. Yeah.
change that I think we should try and
Yeah.
adopt, which is
Yeah.
we don't want to give finality at the cost of, why do you make the parties suffer if generally there's a poor quality award? So can you marry that with providing potentially appellate mechanisms within an institutions to
Absolutely.
ensure that poor quality
Absolutely.
awards are weeded out? So I think that's the direction we need to move towards, to
Hmm.
say, courts, we recognize you're overburdened, so we don't want to burden you. But equally, we don't want to leave the parties in the lurch by not giving them a mechanism for appealing against these decisions. So, how do I do this? Maybe we have arbitral institutions which start creating specific frameworks for it. And I think that's the direction in which I think we should move in terms of accountability, finality, etc., etc.
It's
So,
interesting you say that, because I'm sorry I'm
no, 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 please.
interrupting that line of train of thought, but I just wanted to say it's interesting you say that, because last year, 2 years ago, I joined Leiden for their advanced LLM in international disputes, and as part of my thesis, this is what I looked at. But I looked at in the context of investor-state disputes and the legitimacy crisis. And one of my recommendations, and I advocated for it actually, is we should have an opt-in convention where there is a standing appellate body, and anyone who wants to be within that system can opt into that convention, have that standing appellate
Yeah,
body oversee all arbitral awards. And because at the end of the day, apart from finality, it also sort of creates
correct,
a predictability and coherence in the system. You
correct.
cannot, you would know before going in based on the appellate how the appellate body has consistently held in similar facts and circumstances
Yeah.
previously. So it sort of creates a universal jurisprudence, and I think makes arbitration much more predictable, coherent.
Right. Now, agree. We need to come up with systems like that. I think, we've gone on for far too long with assuming that arbitrators are gods who never get it wrong. We need to move away from that.
Yeah.
Yeah, I think there was a network issue. Can everyone hear everyone? Okay.
Yeah. And we'll just
Yeah,
edit
we'll
this
just
in
edit this.
the post
So,
production.
so I think,
Right. So with
yeah,
yeah,
with this, I think
Akash.
we'll move towards move. I can't see. I think, yeah, can't hear you for some reason.
Sorry, can you just repeat that so that you can edit the entire thing with me with my head down
No, no,
also?
no. We have a
Yeah.
No,
editor who will take
we'll
care of it. It's
we'll
not a
remove
problem.
all of this.
No, so
Yeah.
I think what we were saying that from where we started and where we have led this conversation, I think it's time that we move back towards the central theme of what we wanted to talk about. That how, in terms of accept what is being done, what are the emerging trends in arbitration you are looking at, and in terms of the interference of the emerging trends in arbitration with technology, vis-a-vis AI. So what are the things you are
Yeah.
looking forward to? What are the things you see are emerging right now within the next 5-10 years we'll see huge importance of those things in arbitrations.
Yeah. So, there's a couple of things that have happened, and I think there's a couple of things in the pipeline that I'm interested about, right, and excited about. The first one is the role of AI and generative AI in document review. So when we've been talking about particularly complex arbitrations, the volume of documents has been so enormous that frankly it's been very difficult for arbitrators to actually digest all of that information and actually make sense of it. And the more we are able to get predictable outcomes, or at least outcomes which have an ability to confirm and verify, arbitrators will really like that. And I think that will improve the quality of decision making. So if you are able to interact with documents, converse with documents, and basically ask, your system to say, hey, this is what the claimant argued. But is there anything in the documentation which points a different way? I mean, are there documents that I should be careful about? Should I review? Those are the kind of questions that I think you will be able to ask already with existing systems, but I think you need to tweak them a little bit. And those are the kind of solutions that we're building, which are worth looking out for. The second is ability to work seamlessly across geographies like we've never done before. So one of the things that we're doing at TERES is transcription is one. We also have simultaneous interpretation. So you may be a person speaking in French, but I will be able to listen to it in English, and I might be able to answer in English and you will hear it in French. And likewise, maybe another person in Korean and Japanese and what have you. And that means your ability to communicate across geographies is now suddenly significantly better, which means a wider pool of arbitrators, a wider pool of counsel, and that will likely make it a far more global field. With that, I think is also the ability to do more with documents that are already there. Say, for instance, if you have transcripts that are getting generated today you're looking at it as a record which you read through fully and potentially maybe do a control F and find the keyword. But again, you're now able to converse with documents, like you're able to converse with your transcript. So you might be able to say, hey, this is his opening submissions. What do you think my opening submission in response to his should be? So can you give me pointers on the key points that I should address? Maybe take that further. We are looking already at things like sentiment analysis. So can we look at transcripts? Can we potentially look at video recordings? And can we get facial expressions to tell us, is the person lying? Are they confident on these issues, right? And that's already happening if you look at it in jury trials in the US. So if you look at the kind of algorithms they already have, they have cameras facing all of the jurors, and like every little twitch of the eye, they say, okay, we'll remove this juror. but that's not yet gone into decision making. And I think there are risks with it, but I think we are going in the direction of saying that there are more data points, information points that we may be able to analyze significantly better in the future than we have been able to do so far. And that might also mean helping things like summarization a little bit. Say, for instance, if I'm saying something and if I want to emphasize a point, there is a tonal change. There is all of those things. If you're able to pick up in the transcript, and when if you're doing a summary, and the summary can prioritize these words which I'm emphasizing and therefore make the summary a little better. So those are the kind of things where work is happening. All of these are things that I'm very excited about, and that taken with hyperlinking. Like, I mean, hyperlinking, I think, is too low tech, but has immense potential. So every time you're reading a document, if you're able to correlate that document with all the artifacts that form part of it, whether that be audio, whether that be video, whether that be an argument, whether that be anything, right? And being able to do that in a more interactive fashion, all of these, I think, are going to play a huge role in how decisions are made in maybe the next 5 years. And all of that, while it may take some time for this to get picked up in big value international arbitrations, I think they will start seeing adoption in small value disputes far quicker. So for the kind of disputes where we have not had courts because they're too low value, and courts are too expensive, or arbitration is ridiculously expensive for them to be dealt with, you're looking at online dispute resolution, and I fully predict automated dispute resolution to become the first step of the journey here. So you have an automated dispute resolution, you create a funnel. Maybe out of 100 cases that come, 5% of them go to a human for decision making, but 95% of them get resolved with very advanced algorithms, which are constantly learning with potential biases, being corrected for, etc., etc. I think that's another wave that we will see with smaller value disputes. I think they will be the pioneers of change.
I'm happy you actually brought up the online dispute resolution discussion, because I remember you also piloted this concept. You founded the Center for Online Dispute Resolution. It's been quite a while now. I think
Yeah.
back then it was still new, and now once you were there on the scene, now I've seen one or two other uh, platforms who do provide that service as well. But now that we have brought this up, how has the experience been with Online Dispute Resolution Center? And more in terms of, I'd say, acceptability and enforceability, and just the convenience of the parties. How has the experience been, and how
Also,
do
I
you
think
look at it?
one
Sure.
addition to that question would be like in terms of, has there been a difference in terms of enforceability of a physical or an online? So, have you seen the dichotomy in terms of approach of courts in terms of if you go for enforcement of such an award?
Again, very good question. Not as easy to answer. So far as ODR itself is concerned, as a movement, it has gained significant traction. So, if you think of some of the players who have adopted it, obviously the banking, non banking financial services sector was the first to pick it up. But now you have regulators like SEBI who have made it mainstream. So, the SEBI, or the Securities Exchange Board of India, has now said that every single securities market transaction, if there's a dispute, you will go through ODR. So, to that extent, it's no longer an alternative that people are experimenting with, right? In that ecosystem, the SEBI has gone so far as to make it self-enforcing, which means that if you do get a decision, because the market participants are all operating within the SEBI framework, and the SEBI has the ability to, control licensing, permit people to carry out trades, it's far easier for them to also sanction parties who are non-compliant with decisions made in that ecosystem. So that has made the entire process a lot more robust, and it is done entirely through ODR mechanisms. So we've seen a fantastic reception there. And there we're being able to do things which were previously unthinkable. So conciliations within 20 days, arbitrations within 60 days, ability to do conciliations and arbitrations in regional languages, ability to get in touch with people and conduct hearings asynchronously sometimes, which means that you ask parties for documents, they submit it at their leisure without all coming in together at the same time, or even when it is done synchronously, you are able to bridge language region barriers because you're using online dispute resolution. The next step, even in this journey, will be to understand and distill dispute categories and say, okay, if it is mis-selling, if it is unauthorized trade, can we ask for certain basic set of documents already, so that the dispute resolution process is more efficient? Uh, Taking that to the next level, can I get information on the trades directly from the market participants' servers so that there is no question mark on whether this information is authentic? So, moving a little bit more in the direction of blockchain, but not really blockchain, because now you're not all on the same blockchain, it's not all on the same ledgers, but at least there are certain trusted portals from which you're extracting information. Similar exercises are now being thought about in the account aggregator ecosystem with Sehmati, looking at ODR, right? So you see some of the forward-thinking regulators already adopting it. On the other side of things, when we're talking about really low-value disputes, so banks and non-banking financial services sector was among the first to pick these up, and those are the kind of
Yeah.
cases where we've seen cases go to court for enforcement and challenges. None of our awards have been set aside, so I'm quite proud of that. But I know that there are certain awards which have been set aside, but not because they've been done online, but because they were breaching this whole unilateral appointment of arbitrator
Yeah.
jurisprudence. And
Yeah.
even, I mean, earlier today we had a judgment on that, but
True.
I don't want to
True.
go into that one, right?
Hmm.
But to say that the courts have frankly seen ODR as just another ADR mechanism, and where they've found ODR to be failing, they have been willing to set aside arbitral awards. But where ODR has not failed in due process and being fair and unbiased, they've upheld those awards. So our experience has been entirely positive, and where there have been awards that are being set aside, it's more for jurisprudential reasons which are frankly legitimate and not because they are ODR at all.
Now, Vikas, for just one question, I want to pivot away from AI, because we spoke about the judgment that came out today. I don't want to talk about that. There was another very, very recent judgment which discussed venue and seat. And venue and seat has been a very conflated issue for some reason in India. There have been many, many, uh, pivots over the years in terms of how the courts have looked at seat, venue, closest connection test, and so on and so forth. And because this is a very recent judgment, I just want to have your view on that in the context of the way forward
Yeah.
and aligning India with international practices, at
Yeah.
least when it comes to these things.
Yeah, and Paras, I think it is a classic case of making a mountain out of a molehill. I mean, it should have been a relatively simple issue to solve. I mean, they really should have said, listen, if you've given a venue, that's the seat, unless there's something outrageous that tells me that this can't be the seat. That should have been the position from day zero. Why it wasn't, we don't know. But thankfully, I think over the course of the last few judgments, we are starting to get to that point where they're saying venue is seat, unless there's something outrageous to point the other way around. And they've also given some hints as to what those pointers might be. But frankly, I don't think in any of our cases we will meet that threshold. So we can now safely assume that if someone's provided a venue of arbitration, that will be taken as a seat of arbitration for all practical purposes. Internationally, that dispute has not been as reaching, because frankly arbitral clauses have been slightly better drafted. Of course, I mean, I'm not going to say that there are no pathological clauses internationally, but I think we've had some experiences with poorly drafted clauses which have over the course of many years become standard form contracts across multiple departments. So we've had to deal with this issue more often, and internationally maybe they've had a slightly simpler approach to these issues, so maybe they haven't had to do as much jugglery. And also, India is a big country, so for us a venue makes a huge difference, because if I have to be going to Delhi to do all of my arbitration sitting in Bangalore, that is a problem. But whereas in most of your other jurisdictions, it's, I mean, where you want your seat to be is likely where you want your venue to be also. So there was very rarely that dichotomy. So I think comparing it with international best practices is also doing disservice to the diversity and the breadth and length of India as a country. So yeah, that's where we are at, and I'm glad we are moving into some degree of predictability in that realm.
So I think since we are on
Okay,
the
that's yeah.
academic discussion, I have one more question for you. I think my question revolves around like being from NLS. My question is like you seem to go to NLS, have classes, take courses. You're involved in academia. If a fourth year or third year or fourth year student comes to you today and tells you that, Vikas, give me 5 pointers I should understand and internalize for me being a good arbitrator 10 years down the line. But I'll have to do that hard work at the beginning. But what are these 5 things you will tell someone? The way you do these 5 things, you have a better chances of becoming a good arbitrator.
Sure. Thanks for that question, Akash. And I think this also is a good way for me to answer a point that I had flagged earlier, which is, when Paras said, how can we become the next Dubai or Singapore? And I'd said I have a slightly different view, right? So let me give you my view on that, and then I'll lead you to those 5 points, which I think are relevant. Singapore and Dubai, I don't think are even worth trying to emulate. And I'll tell you why. India is either a capital importer or a capital exporter in its own right, and it's too big to aim to be neutral. We will always, in every single transaction, be a heavyweight, right? Either as a recipient or as a supplier. Singapore, your Dubai or Geneva or your smaller jurisdictions, they've always been neutral because that served them well. They've been fairly insignificant to influence policy as a heavyweight. And so they have taken on that mantle of being neutral and therefore attracting these disputes. I would much rather they continue to attract those disputes, because then that will mean that India is one of the heavyweights and the other party doesn't want to seat their arbitration in India because, I don't want to trust your independence and neutrality, just as I wouldn't trust the neutrality and independence of a China or a Russia in a transaction involving them. So I think it's counterintuitive and probably against the policy agenda of the government over many years, which is to say make India the international hub of arbitration. I'd say don't make India the international hub of arbitration. If anything, make India the international hub of councils who can do international disputes, but
True,
not the seat
true,
of arbitration.
true, true.
Have the seat outside of India, because that neutrality is important. And that leads me to, so sort of the 3 or 4 points that I can say to students who are looking into that space, right? Arbitration at the end of the day is trial. Trial is like any other civil proceedings. Unfortunately, the way trial has been conducted in India, particularly in civil courts, has not really been to the standard where you can learn very much to emulate in a properly run international arbitration. But I must say that commercial courts are doing a significantly better job. And
Yeah,
I would, in fact, now today feel more comfortable doing a trial in the commercial court than before some of the domestic arbitrators, right? So I
absolutely.
would say if you do want to do commercial arbitration, then you needn't only do
Okay.
arbitration, which is the journey I started off with. There's very good prospects with learning trial in good commercial courts. Bangalore actually has a good commercial court. Delhi has very good commercial courts. Unfortunately, I don't think I can say the same about Bombay at this point in time. But pick, when you are doing what you're doing, which is a court which has good, solid jurisprudence, good procedures, good seniors who will give you the opportunity to actually experience these various facets of trial. And once you do well in trial, and frankly, arbitration, and I mean, Akash and Paras, you'll know this, 95% of trial is written advocacy. It's very little that oral advocacy really changes the entire case, right? I mean, a lot of the hard work is done in your pleadings, and when an
Yeah,
arbitrator is drafting
yeah,
an award, they're mostly looking at your pleadings and your closing submissions.
yeah.
So the second thing I would tell them is to focus on written advocacy and pay incredible attention to what they can do to make that of top-notch quality. And that means avoiding things like maliciously, fraudulently, intention. These are expressions which have become so commonplace that no
Yeah,
one really takes those words any seriously. But and this is one of the things I learned, right, in my practice, and when I was being trained, they said, don't write a single word which you cannot put your heart and soul behind and justify. Because what that means is that the tribunal will take you that much more seriously. So One, say it plainly because that's all you need to say. Two, say it only to the extent that you can prove it, because then there's greater credibility to everything that you say, rather than overstating and hoping that it'll somewhere get balanced out. And three, it also makes it easier for you to make it more crisp. They're shorter pleadings, which are more easily readable. So you're better able to communicate it also. So for all of those reasons, to hone your written advocacy skills is probably the most important skill of being a good international arbitration practitioner. The third point I'll say is, while of course international arbitration is really exciting and interesting, there's as much excitement and interest in domestic arbitration also. So, for instance, I mean, I'm doing one arbitration now in Qatar, but frankly, the fact that it's Qatar law governed is irrelevant. We are running that arbitration on facts. It's very difficult for someone to say the contract says X, but because of this position of law, you should like completely ignore the contract. It happens, but very rarely. So, like 90% of your work will be on factual interpretation. And there, domestic, international doesn't make a difference. Work on matters where you will get your teeth into these kind of issues. And tomorrow, whether it's a domestic arbitration, whether it's an international arbitration, you will do well. So, focus on your ability to digest complex facts, your ability to digest voluminous documents, and that will stand you in good stead across board, whether it's domestic or international arbitration. The fourth is to actually do as much as you can to learn from people and be selective of people who you learn from. Flamboyance and courtcraft that might work in certain jurisdictions may not always work in others. So, for instance, let's say in the Supreme Court, I will not name lawyers. If you are able to get away with screaming because that's who you are, that may work in the Supreme Court. That will not work in an arbitration. If you are, again, I will not name lawyers, the kind who will say, पढ़ के तो कोई भी आर्ग्यू कर सकता है, बिना पढ़े आर्ग्यू करने के लिए तुम्हें मेरे पास आना पड़ेगा. That's the kind of
For some
attitude that
reason,
people
that
have.
that that sounds oddly, specific as an example.
It it is, but I will not name the person. But that's the kind of attitude that will not carry you very much in
Yeah,
international arbitration. So I think it's
true,
very
true.
important to choose your mentors carefully if you want to do properly. These practices unfortunately have worked because, and I mean, these are smart lawyers. I'm not saying that they're not smart, but it's unfortunately the system is designed such that you have a flap, you get more time. The courts have such limited time that because you have only 10 seconds, that face value matters. So it's about all building that face value. It's not really as much about like preparing for the case. Some of those practices in international arbitration can be very risky because in international arbitration, invariably, you'll have a lot more time. It may not be as much time as civil court proceedings with 10 years, 20-year trials, but it's still enough time for you to actually convince and persuade people on the merits of the case rather than purely on style and flamboyance. So focus on the merits a lot more than you will focus on these other attributes is again something that I'd say. And lastly is be willing to be challenged in the way you do things, whether it's the way you write, whether it's the way you argue, whether it is the technology that you're using, whether there is a certain way you're doing things. Always be willing to say, maybe I'm not doing it the best way I can, maybe there is a better way to do it, and therefore have that mindset of being open to learning. And I think these 4 or 5 points, if people can emulate, then there's absolutely no reason why they can't be
No, no.
super successful.
Absolutely. I relate very much to everything you have said, and I think to all for all the young practitioners who would listen to this podcast,
Yeah,
who
I
would
think I think
watch this podcast, I think these are very,
we will
very
have
good
a
points, and they can
separate
really,
clip of this only for like students in
yeah,
terms of who
yeah,
are
yeah.
want to build a practice in international arbitration. I think that would be, and I think what Paras was saying and what we also as a firm align with and as partners is always using a crisp language and not unnecessarily expanding the pages, because I think that is as a practice
Yeah.
which we have seen, like because I think all of us have uh, interned in trial courts, have seen trial courts, how trial courts work, and we have seen the submissions being made there, and it's just like the amount of words being used, like you said, all these words are being repeated, maleficious and other things. They just keep
Yeah.
on repeating these words.
But Vikas, I wanted to just follow up on this last question that Akash asked, and my next question has three parts. The first is, if you are a young practitioner in India today, without your 8 or 10 years of experience in HSF, you're starting out in India, you want to set up your own practice. What are the do's and don'ts, right? Uh, the second is when we speak about making Indian council work worthy enough, because fortunately or unfortunately, I mean, it is the way it is. We don't see a lot of Indian practitioners actually on the global scale. Most of the big ticket disputes still go to American or European law firms. India recently got noticed in a BIT claim, and even though there is an Indian firm, but they are still the second counsel, and the main counsel is still, I think, a Canadian law firm, if I'm not wrong. How do we change that perception?
Yeah.
How do we, and the third part of my question is, looking back at your journey, if there was something you could change about it, what would that be?
Right. I mean, I'll try and answer to the best of my ability, right? Do's and don'ts, I think it mirrors a little bit of the sort of 4 or 5 points that I said in response to Akash's questions. But from starting a fresh point of view, right? I think while people need to be confident in their own abilities, it's also having that humility to recognize that there is things to learn. And while you may have done fabulously in college, the practical side of things has a little that you can learn from. And I think a lot of that has to do with commercial acumen. So if there's one skill that you should focus your efforts on, one of the do's would be to, in a commercial context, if you're doing commercial disputes, is to acquire that commercial acumen. Start looking at it way businessmen look at it. Why do people take certain decisions? And that can help you either say, don't arbitrate because you may have a fabulous legal case, but it doesn't make any financial sense, and so settle. Or it could say, in a legal dispute, understand why what is happening, and that might help you better communicate things to the arbitrator. In terms of don'ts, again, it goes back to some of the 4 or 5 points, but maybe another don't I can talk about is, don't be disheartened by immediate successes that you might see elsewhere. And I think this goes particularly for the social media world that we live in. Like a lot of, I mean, what you see on a LinkedIn post is only the positives, right? As they say in Kannada, Yellar mane dose tute, which essentially translates to, in everyone's house, there are certain problems. They may not parade it out there, and maybe they only talk about the good things. So for you to then see only the good things and say, oh, my friend has become one partner, they're earning millions, they're doing this transaction, that transaction. Maybe they're being successful, but that may not be the full story, and maybe that's not your story. You don't have to follow what another person says. So you chart your path, be true to it, and you're not in a sprint, you're in a marathon. As a lawyer, your career spans anywhere between 50 to 60 years, right? So really don't worry about saying, okay, they've gotten it first, I need to get there. Chill out, get your basics right, and once you have that, you will do far better. So I think that's the one don't that I'd say. Don't look at social media for perspiration, for inspiration, sure, but yeah. The second point that you talked about in terms of, there are Canadian lawyers that are there. I mean, I'm an economics background, right? And I see myself as saying, wherever there is some specialization, there is no harm tapping into that specialization. There are Indian lawyers who are fantastic in international advocacy, so yes, but have they done as much investment treaty work? Maybe, maybe not. I mean, there are certainly the Indian firms who have done investment treaty
Yeah,
work, so you
yeah,
must look at it. But there are firms who haven't, or maybe it's not investment treaty work, because it's a bit like saying, okay, are you a civil court lawyer? But it will probably be a question of, have you done investment treaty arbitration in the pharma sector? Have you done investment treaty arbitration in media sector? And maybe there are people who are specialists. And I don't think we should be proud enough that we'll say, okay, we'll never look at specialization elsewhere. But if that comes at the cost of ignoring local talent simply because they're local, of course, you're doing a disservice to it. But I think that's moving. We've seen more international arbitrations where Indian lawyers are being counseled, and I can talk about personally, right? Especially in the
yeah,
Middle East, a lot of
yeah,
the work traditionally went to English barristers, and over the last 3 years, I have done at least 6 international arbitrations in the Middle East, and there I've gone in purely as counsel, with the local firm actually doing the advocacy, and they see value because they say English barristers are potentially expensive. There are experienced practitioners elsewhere. Earlier it was Singapore, and then they're saying, actually, why not India? Because there is good talent available there. It is, the tides are changing, and I'm positive that over time that it'll get much better. And the last point that you talked about is on
If you could
sorry,
change one thing,
change one thing that I
yeah.
could about myself. I mean, there's a lot I will change. Yeah. I mean, I'm by no means perfect. Um, but I think if there's one thing I would change, it would probably be writing a little more when I was less busy. Like right now, I really struggle to find time to think as academically and critically. I mean, even now I try and do it as much as I can. For instance, commenting on bills, or whenever there's a judgment, look at it critically. But your ability to write a well-researched, peer-reviewed journal article which covers a whole variety of topics the way you want to, unfortunately, I don't have the time. And I think as younger practitioners, as students, what we don't have with being busy with work is time and the ability to learn this multitude and being a little bit more open of the kind of ideas there are. So maybe if I had to turn the clock back, maybe I'd do a little bit more of that.
I think
True, I
we
think
would be,
even Akash and I mean, all four of us here at the firm, I think we do try and write as much as we can, but I think we still sometimes feel if only we had more time. And I think that's the same thing I'd say about this podcast because I still have certain things I wanted to ask, but I think we are
yeah, I
now
think
running
I
out
think
of
we can
time.
conclude on
Uh,
last point. I think one point which I wanted to check. So, because as part of practitioners across practice areas, we have seen a lot of tech being used. Like I remember in terms
Yeah.
of DD, we have tech where you upload documents and you get findings. You have drafting, in terms of drafting, you give certain clauses and there will be a draft which will be presented to you. And as part of this podcast, also, we were talking about in this episode itself, we were talking about situations where we can get an order drafted, we can get get the statement of claims drafted, among other things. Now in terms of the legal tech space, being someone who is involved with the space for the last 5 6 years, I would say, what do you think will be the next revolution in terms of legal tech in India? And considering the practice across practice areas, like just not restricted just to arbitration, but across practice area, where do you think the next revolution in the legal tech will be?
Yeah. Actually, Akash, I want to make just one small point before answering that because I think it's useful for people, especially younger students who are looking at it. Um, when you were talking about how there's so many things we can do with AI, right? And there's also this fear that it is going to make younger lawyers redundant and things like that. One thing I wanted to say, which is critical thinking is still very much
Yeah.
in the human realm at this point in time. If you look at strategizing for a case, if you look at even reviewing whether that draft that is being generated actually meets the business needs of the client is still something that a human needs to do, right? And so prompt engineering is something that is a skill that one must acquire. So it's not enough now that you know how to do Westlaw searches and Manupatra searches, but you really must now know how to work and interact with AI. Those are the kind of skills that you will pick up. And that feeds in with my answer to the question that we're asking, which is what is likely to the next revolution is, I think when we're looking at a fully digital journey, we'll start seeing the pieces that you're talking about starting to fit like jigsaw puzzles in that piece. So the next wave of revolution, if you can call it that, is actually integration of these various developments. For instance, let's say what Sehmati is now trying to do is in account aggregators, they're trying to pull all your information from all of the publicly available, or whatever, all of the financially regulated institutions and keep it available for you to access for whatever products and services that you have. Next wave of that is, if you have dispute resolution, which can tap into the same repository of documents and knowledge. That integration will then make the entire process seamless. So it will make evidence collection a lot more straightforward, proof of documents and proof of things a lot more predictable. And then next, that if this piece can be linked with courts, then courts then don't have to rely on certified copies of awards. They don't have to rely on, the trial court records being sent to them, things like that. This integration across various verticals is, I think, what the next change is going to be. So it's no longer going to be in silos. It's going to be more cross-pollinated.
Thank you. I think that covers.
And that's fascinating because I'm sure you have given us a lot to think about and ponder about. And I think my one takeaway is that for some reason it is the government that seems to be at the forefront of adopting AI and tech and things like online dispute resolution more than the private sector, because traditionally it seems to be the other way around. The government has always been the last mover. But this was a very fascinating discussion and conversation, because we are so happy and so grateful that you joined us for this conversation today, and it was really wonderful talking to you on all things tech
Yeah,
and law.
Vikas.
No, it was really my pleasure. Thanks for having me
Thank
over,
you,
Paras and
Vikas, for
Aakash.
being there. And I think it was a lovely chat. I think I would not call it like a podcast. I think it was more of a lovely chat where we were like just throwing our understanding and questions to you, and you were graceful enough to answer.
No,
So
doing my best.
thank you, thank you.